At this time, the chair is going to call our esteemed former colleague, Scott Hochberg, here to speak against the bill. Scott, we're honored to have you here with us today.
Thank you, Mr. Chairman. It's an honor to be here. It's an honor to be back on one of the committees I had the privilege of serving on. Thank you for your hard work. I am Scott Hochberg, and I'm here representing myself, and I'm here in opposition to HJR 110. One of the things, when people ask me what I'm proudest of in my work in the legislature, I often talk about religious freedom issues that I worked on. And I had the privilege to work with Governor Bush at the time to pass the Texas Religious Freedom Restoration Act in 1997. It was one of the hardest bills I ever worked on because we were trying to do something very specific. We were trying to fix a very specific problem with one court case, as Representative Isaac alluded to, and we were trying to do that without generating any unintended consequences. That's hard work. Y'all know that. We ended up not with a provision that is this long, like the HJR in front of you, but a bill that was 9 pages long. And it passed with strong support. It was signed in a ceremony by Governor Bush. Senator Sibley was my co-sponsor. We had a wide coalition of religious interests who supported the bill and worked on it. We had a wide coalition of conservative to liberal, Democrat to Republican on this bill. If someone were to propose to pick that bill up and put it in the Constitution, I would cheer, and I would be here in support. But this constitutional amendment leaves out some very, very important language and adds some language that was never in the Texas Religious Freedom Restoration Act as it exists today. First of all, one of the most important things that this doesn't do is we talked about a substantial burden on religion. We talked about substantially motivated by an act that was substantially motivated by your religious beliefs. The word substantial is not in here. So what does that mean? When I talked about this on the floor last time, it happened to be the night that Mr. Guerin brought us all ribs for dinner. And that was dinner in the chamber, and we were staying long, and that was the only dinner in the chamber. And I said, well, you know, if I were true to my religious tradition, did you have sliced beef? Was it the ribs were the main idea, and I said if I were true to my religious tradition, it would be a burden on me to have just ribs available. But it's not a substantial burden. It's certainly not something that you'd want to have a legal case over. But more seriously, along the same lines, in our prison system today, there is one unit that has a kosher kitchen. And religious Jewish inmates who want to maintain and continue to practice their religion can be transferred, if they're in the right security classification, to that particular unit. It's outside of Houston. I've had the pleasure of visiting it. That's a burden, particularly if their family is in a different part of the state or in one of your parts of the state. Is it a substantial burden, sufficient that you would have to put a kosher kitchen in every prison? No. So when you take the word substantial out, you do major things. On zoning. Zoning is a big issue, and we have a very specific section in the Religious Freedom Restoration Act that says we're not trying to change case law on zoning. There's been case law on religion versus zoning for years. This bill wasn't trying to change it. If you talk about a burden on religion, let's say your neighbor in a residentially zoned subdivision that you live in has a piece of property that they'd like to donate to the congregation to build a church. Well, the case law says basically, well, for the church to go over there and use that piece of commercially zoned property, that's not a substantial burden. It's a burden, but it's not a substantial burden. You take substantial out, and I can demonstrate, hey, I got a good price on that property. It's a burden for me to have to move. Now, where that goes in the other direction and where this law has been used successfully, and it's the Sinton case that the representative mentions, is if a city says, we're going to create zoning so that you can't build your church anywhere in the city, or you can't build your religious outreach anywhere in the city, then that's over the line. Because we haven't just created a small burden. We've made it impossible for you to practice your religious belief. And if you don't have a compelling public interest to do that, you can't do it. And in fact, the Sinton case, the one you mentioned, was Texas RFRA was used in that case. And after the case was heard and the ruling was in favor of going back to the lower court and determining whether there was a substantial burden on religion and whether it was the least compelling means, one of the law professors who was probably on that sheet, and I haven't seen it, but one who's been very involved in this over the years, wrote on his blog, the Supreme Court of Texas has unanimously given Texas RFRA its intended meaning to provide real protection for the exercises of religion. There's a variety. You heard the testimony about a question about whether we needed a carve-out essential or a protection for abortion laws. You would not be surprised to know that there were a lot of protections that came to us that wanted to make sure we weren't messing one way or another. One of it was civil rights. There is always tension between various rights in the federal Constitution and our Constitution. And we wanted to make sure that this law that we passed did not affect one way or another the line of case law on civil rights. So there's language to that effect. It's not in this JR. And so what does that mean for the civil rights protection we wrote in the statute? Not sure it's there. Zoning, as I mentioned, prisoner cases. Y'all know that it's sort of a hobby in prison to write writs. You got folks who have a lot of time on their hands, and they like to look for any case. We wanted to make sure, and the prison system wanted to make sure, that we weren't creating a situation where every one of those cases would have to be litigated, and the prison system would have to show that they had a compelling interest, compelling security interest in a restriction they had placed on somebody. So we, again, put a provision in that specifically dealt with that and said, we're going to give the prison system the benefit of the doubt. We're going to assume it's a security regulation, it's a compelling interest, it's a rebuttable presumption. You can come back and argue against it, but we're not going to open the door for who knows how many prison lawsuits. I could go on. I won't take a lot more of your time. There's a couple of other things in here. One was a section that the tort reform folks wanted us to put in, just to make sure that this wasn't creating a new cause of action. And so there's a limitation on the amount you can actually collect as compensatory damages for a violation of Texas RFRA. And there are procedures that you have to go through where you give the government the opportunity to cure the defect. That's what we're really trying to do. We're not trying to create lawsuits. We're just trying to allow the government or to require it where necessary to create an exemption. I passed a bill before this passed just as an example of where this stuff comes about. A judge in Houston had decided that there was a dress code in her court, and the dress code in her court said no hats. Well, Orthodox Jews believe that they need to cover their head inside a building, and so when an Orthodox Jewish man was called as an expert witness, she required the gentleman to remove his skull cap or not testify. Mr. Crabb and I passed a piece of legislation that says you just can't do that. There's no compelling interest there. Those are the kinds of things we talked about. Mr. Guerin was quite eloquent last time when this bill went to the floor and did not get the requisite 100 votes. And he talked about a bill that he passed that says that if there is a funeral of a serviceman and a group for their own religious reasons chooses to protest that, they've got to yield space. Well, that's a burden. Is it a substantial burden? No. And so you put this in the Constitution without spending, I got to tell you, it was hundreds of hours with legal experts on both sides to work out every single word on a statute that you can come back and fix. You put it in the Constitution, and you don't give it that kind of care, and you don't give it that kind of examination. And now you're going to have courts deciding whether or not Mr. Guerin's law stands, whether or not the prison section stands, whether or not everything in Texas RFRA, other than the words that they've chosen to take out and put in the JR, have any meaning at all. This has worked. Since 1997, this has worked. I don't know that there's anything I've passed around here that hasn't had to be tweaked in some way in that amount of time. I think we should leave it as it is. I think we should not amend the Constitution lightly on this very, very, very important issue. And I appreciate your time, and I stand for your questions.
Chairman Guerin has a comment.
Thanks for coming.
Thank you, Chairman.